Good morning, Dr. Amalina. Today, we are from Tutorial 11, Group A, and we are going to present Contract Law 1 presentation. Our group members are Lim Ying, and Jingyi, T. Whitney, and Teo Chi Fang. In this question, the first issue is whether Cepat Sehat Sdn Bhd advertisement constitute a legally binding unilateral contract or merely an invitation to trade, and whether Ida is entitled to claim the 10,000 reward. For the general rule, Section 2A of Contract Act 1950 states that an offer exists when one person signifies willingness to do or abstain from doing something with a view to obtaining the assent of another. The relevant cases is Carlier against Carbolic Smokeball Company, 1892. The issue arose whether the Carbolic Smokeball Company advertisement constitute an offer or merely an invitation to trade. Whether Mr. Carlier is entitled to claim the £100 reward. The fact of this case is Carbolic Smokeball Company advertised that it would pay £100 to anyone who caught influenza after using its smokeball 3 times daily for 2 weeks according its instruction. The £1,000 had been deposited in a bank by the company. Mr. Carlier bought the smokeball, used it exactly as directed, and still contracted the influenza. Therefore, Mr. Carlier claimed the £100 reward, but the company refused to pay. The court held that the advertisement was a unilateral offer to the public. Mr. Carlier accepted by performance as she used the smokeball as directed and still got influenza. The £1,000 bank deposit showed the company's intention to be legally bound. The consideration existed through her action benefiting the company. Therefore, a valid contract was formed and the company was liable to pay £100. In conclusion, the advertisement constituted a unilateral offer and not merely an invitation to trade. Mr. Carlier was entitled to claim the £100 reward as she had performed the condition of the offer, forming a valid and enforceable contract. The next case is Patrick against Chipperton, 1968. The appellant inserted an advertisement in a magazine containing words such as quality British ABCR Bramble Fish Cook Bramble Fish hens 25 shilling each. The advertisement was inserted in the general heading of the classified advertisement and does not containing any direct use of words such as offer for sale. After that, Mr. Thompson was interested with the advertisement and purchased a Bramble Beach hen as advertised and enclosed a cheque for 30 shillings for the payment to the appellant. On the appellant appeal against his conviction for unlawfully offering for sale a Bramblefish hen under Section 6 Subsection 1 of the Protection of Birds 1954 Act. The issue is whether the advertisement is merely an invitation to trade or an offer to sell. The court allowed the appeal and held that the advertisement was not an offer but only an invitation to trade. This is because A. Shaw J. state that the insertion of an advertisement in the form adopted here under the title classified advertisement is simply an invitation to trade. In conclusion, the advertisement is merely an invitation to trade and not a binding offer to sell. When we look back into the previous question, we can see two perspectives of Ida and Cepat Sehat. The first perspective is the advertisement constitutes a binding unilateral contract, not merely an invitation to trade. This is because Cepat Sehat made a clear promise to pay 10,000 to anyone who used Immunipatch as directed and still develop a severe skin allergy. The 100,000 deposit with June Bank show their clear intention to create the legal relation. Ida accepted the offer by performance by purchasing and using the product as instructed. The consideration existed also through her time, effort, reliance, and the commercial benefit to the company. Therefore, Cepat Sehat refusal to pay amount to a breach of contract, entitling Ida to get the 10,000 reward. From the perspective of Cepat Sehat, it states that the advertisements are generally invitation to trade, not offers. This is because the 100,000 bank deposit may be argued to be symbolic, not contractually binding. Ida did not complete the full 30 days usage as the reaction occurred after 3 weeks. In addition, full performance of the condition precedent is required for acceptance. This led no valid acceptance occurred and no contract was formed. Therefore, the refusal to pay does not amount to a breach. In conclusion, in this question, the advertisement issued by Cepat Sehat Sdn Bhd is likely to constitute a binding unilateral contract, and Ida is entitled to get the 10,000 reward. The deposit of 100,000 with June Bank show their intention to create the legal relation. For the legal advice, firstly, Ida should take legal action against Cepat Sehat Sdn Bhd for not paying the reward. Second, she should keep all important evidence such as the advertisement, receipt, and medical report. Lastly, she may also complain to consumer authorities for misleading advertising. That's all from my part. Thank you. I will pass it to Jingyi.
Thank you, Ying Ying. And now let us move to the second issue, which is whether Ida and Hafiz can claim the 50,000 ringgit from Johan estate, even though they were not the party to the agreement between Rahman and Johan. Under the common law, a contract only creates a right and obligations between the party who involved in it. This principle is known as the doctrine of privity of contract. It means that only party to the contract can sue or to be sued on it. A third party generally has no right to enforce the contract, even if their name is mentioned in the contract or even if the contract was intended to benefit him. Next. The leading English case on this principle is Chandler and Atkinson. In this case, William Chandler marries the daughter of William Guise. Before the marriage, both fathers has honorably promised that they would give the money to the couple. After marriage, they enter into a written agreement. Under this agreement, William Guise agreed to pay £200 and John Chandler agreed to pay £100 to William Chandler, who was the son and also the groom. The agreement even expressly stated that William Chandler have the power to sue the party to enforce the payment. However, William Guise died without paying the £200. William Chandler then sued the executor of William Guise estate, Atkinson, to recover the money. Issue arises whether a person who is not the party to the contract can sue to enforce the term, even if the contract was made for their benefit only. Next. The court held that William Chandler could not sue, even though he was the beneficiary of the contract and was even named in the contract. He was not a party to the agreement. Furthermore, the consideration for the contract did not move from him but from his father. Therefore, he has no enforceable right and the court dismissed his claim. This case clearly established that a third-party beneficiary cannot enforce a contract due to the doctrine of privity of the contract. Next, the Malaysian position is confirmed in the case of Kepong Prospecting Limited Company and others and Skimmage. In this case, Skimmage was the consulting engineer who helped Tan, the original miner entrepreneur, to obtain an iron ore prospecting permit in Johor. In return for his services, Tan promised to pay Skimmage 1% of the selling price of the ore. Later, Kepong's Prospecting Limited Company was formed to take over Tan's mining operations. In the year 1954, an agreement was made between Tan and the company stating that the company would take over Tan's obligations, including the promise to pay Skimmage. However, Skimmage was not a party to this 1955 agreement. In the year 1955, a new agreement was made directly between Skimmage and the company, where the company expressly stated that they will pay the 1% to Skimmage. When the dispute arose, Skimmage attempted to enforce the agreement. The Privy Council held that Skimmage could not enforce the 1954 agreement because he was not a party to it. However, he could enforce the 1955 agreement because he was a party to that contract. This case confirmed that the doctrine of privity of contract apply in Malaysia. Next. Now, applying this case to Ida and Hafiz situations, the agreement to pay 50,000 ringgit was made only between Rahman and Johan. Ida and Hafiz was not the party to the agreement, and the considerations was not come from any of them. Their situations is more likely to the case of Trinder and Atkinson, even though the promise was made for their benefits but under the doctrine of privity of contract, they have no right to enforce it. Furthermore, this principle is also supported by Coupon Prospective Limited Company and Schmidt case, where the court held that a third party cannot enforce a contract to which he was not a party. In this case, Schmidt could not enforce the 1954 agreement because he was not a party. So, link back to Ida and Hafiz situations, they also not the party to the agreement between Rahman and Johan. Therefore, they cannot enforce it. Furthermore, this principle also supported by a Malaysian case, which is Kopong Prospecting Limited Company and Schmidt, where the court held that a third party cannot enforce a contract to which he is not a party. In that case, Schmidt could not enforce the 1954 agreement because he was not a party to it. Think back to the Ida and Hafiz situations. They also not the party to the agreement made between Rahman and Johan, so they cannot enforce it. In conclusion, Ida and Hafiz cannot claim 50,000 ringgit from Johan as they were not a party to the agreement between Rahman and Johan. Yes. And I will now move to the third issue, which states that whether Ida can enforce her mother promise to pay her 2,000 ringgit per month. Under Section 10 of Contract Act, an agreement is only a contract if it is supported by a lawful considerations. Moreover, in Section 26 further provided that an agreement without consideration is void unless it is fall within a certain exception. One of these exceptions is laid out under Section 26, subsection A of the Contract Act, where the agreement is made out of natural love and affections, but only if the agreement is in writing and registered under a formal law. More importantly, this case involves the concept of intention to create a legal relation in domestic agreement, which form an exception to an ordinary contract law where there is no intention to create legal relations for social and domestic agreement. The leading case here is John and Padawadon. In this case, a mother persuaded her daughter, who was working in the United States, to come to England to study law. The mother promised that she will pay her a money allowance for maintenance, and later the mother bought a house in London for the daughter to stay in. And the daughter also rented out some rooms. After some years, the daughter did not complete her study and the relationship between them have broke up. The mother then asked the daughter to leave the house, but the daughter refused and claiming that there was a binding contract between them. The Court of Appeal held that there was no intentions to create legal relations. The arrangement was merely a family arrangement based on trust and good faith. It is not a legally binding contract, then the daughter had no legal right to remain in the house. Now, applying the law to Ida case. Her mother promised to give her 2,000 ringgit per month so that she could study law full-time. This promise was clearly made out of natural law and affection, which is from a mother to daughter. However, under Section 26, subsection A of Contract Act, such a promise is only enforceable if it is made in writing form. In this case, there was no written or registered agreement, so the exceptions in Section 26, subsection A cannot be applied in either situations. Furthermore, this is an agreement between a mother and daughter, which is a domestic or family arrangement. In law, there is a presumption that there is not intentions to create a legal relationship in such arrangement. This is similar to the case Jones and Padawadon, where a mother supports her daughter to study law and the court held that it was a legally binding contract and family arrangements. Thus, Ida and her mother promise was merely considered to a family arrangement. In conclusion, Ida arrangement is only a family arrangement and not legally enforceable. That's all for third issue. Thank you, Jingyi. The fourth issue concerns whether the Ministry of Health is legally entitled to recover the full amount stated in the scholarship bond, or whether IDA may rely on Section 75 of the Contract Act 1950 to argue that the stipulated sum is an unenforceable penalty. Under Section 75 of the Contract Act 1950, where a contract stipulates a sum payable upon breach, the court may await only reasonable compensation, not exceeding the amount named. In ordinary commercial contract, this provision allowed court to intervene where a stipulated sum operates as a penalty. However, scholarship agreements involving the government or statutory bodies are governed by a special statutory regime, namely the Contract Amendment Act 1976, which was enacted to protect public funds spent on education. Next. Section 4 of the Amendment Act provides that a scholarship agreement shall not be invalidated on the ground of lack of consideration, minority, or contravention of money lending law. This provision confirms the validity and enforceability of scholarship agreements, notwithstanding objection that would ordinarily arise under general contract law. More significantly, Section 5 of the Amendment Act stipulates that where a scholarship agreement is breached and a sum is named as payable upon breach, the scholar and any sureties shall be liable to pay the whole of the named sum. This provision expressly overrides the reasonable compensation requirement under Section 75 of the Contract Act 1950. Next. In Government of Malaysia against Gurcharan Singh and others, the defendant was awarded a government scholarship to undergo training and education. As part of the scholarship, he entered into a bond with the government, which required him to serve the government for a specified period after completing his study. The purpose of the bond was to ensure that the public funds spent on his education would benefit the government through his service. However, after completing the training, the defendant failed to fulfill the required service obligation. When the government sought to recover the expenditure incurred under the scholarship, the defendant argued that the scholarship agreement was unenforceable because he was a minor at the time he signed the bond. And next. The issue was whether a scholarship agreement entered into by a minor was legally enforceable and whether the government could recover public funds when the scholar failed to complete the required service period. The federal court held that the scholarship agreement was enforceable despite minority. The court recognized that education constitutes a necessity and emphasizes that public funds spent on education must be protected. Accordingly, the government was entitled to recover the expenditure incurred. This case is significant because it highlights the strong public interest in safeguarding government investment in education and exposes the limitation of relying solely on general contract principle. It ultimately laid the foundation for legislative reform, leading to the enactment of the Contract Amendment Act 1976. And next. The statutory provision was later clarified in Bank Negara Malaysia against Mohd Ismail Ali Johor and others. In this case, the defendant was awarded a scholarship by Bank Negara Malaysia and was bonded to serve for 10 years after completing his study. However, he resigned after serving only 1.5 years. When Bank Negara Malaysia demanded repayment of the full bonded sum, the defendant argued that such repayment amounted to an unfair penalty, particularly given his partial service. The court rejected this argument and held that scholarship bond was valid and enforceable under the Contract Amendment Act 1976 and that the repayment clause did not constitute a penalty. Next. The issue before the court was whether the bonded sum payable upon breach of a scholarship agreement constitute an unenforceable penalty under Section 75 of the Contract Act 1950 and whether the scholar was entitled to a reduction of the bonded amount due to partial service. The Supreme Court rejected this argument. The court held that Section 5 of the Contract Amendment Act 1976 is clear and mandatory. Where a sum is named in the scholarship bond, the entire sum is recoverable upon breach. The court further held that it has no discretion to reduce the amount based on partial service or penalty considerations under Section 75 of the Contract Act 1950. This case confirmed that scholarship agreements are governed by a special statutory regime and that ordinary penalty principles do not apply. Next. From IDA's perspective, she argued that it is unfair for the Ministry of Health to demand repayment of the entire bonded sum when she has already served 2 out of the 5 required years. She relied on Section 75 of the Contract Act 1950, which generally limits recovery for breach of contract to reasonable compensation. IDA contends that requiring full repayment despite partial service operates as a penalty and that the court should grant a prorated reduction based on the years she has already served. However, when this argument is assessed in light of the governing legal principle, it cannot succeed. Applying the reasoning adopted in Government of Malaysia against Gucharang Singh and others, Aida's scholarship was funded entirely by public funds with a clear expectation that she would complete the full service period in return. By resigning after only 2 years, Aida failed to fulfill her contractual obligation, and personal hardship or perceived unfairness cannot override the public interest in protecting public expenditure on education. Further, Aida's situation also falls within the statutory framework governing scholarship agreements. Her resignation before completing the full 5-year service period constitutes a clear breach of a scholarship bond by virtue of Section 5 of the Contract Amendment Act 1976, where a scholarship agreement is breached and the specific sum is stipulated as payable upon breach, the entire bonded sum is recoverable, and the court has no discretion to reduce the amount based on partial service. Accordingly, Section 75 of the Contract Act 1950 apply only to ordinary commercial contract and does not govern scholarship agreements subject to this special statutory regime. Aida attempts to characterize the repayment clause as a penalty, therefore does not reflect the correct legal positions. From the Ministry of Health perspective, Aida's resignation after 2 years constitute a clear breach of a government scholarship bond. The scholarship was funded using public funds with the legitimate expectation that Aida would serve in the public healthcare system for the full bonded period. The Ministry relied on the Contract Amendment Act 1976, particularly Section 5, which provide that where a sum is named in the scholarship agreement as payable upon breach, the whole of that sum is recoverable. Applying the decision in Ban Negara Malaysia against Mohd Ismail Ali Johor and others, the court had no discretion to reduce the amount based on partial service or consideration of fairness. Section 5 expressly overrides Section 75 of the Contract Act 1950. Therefore, from the Ministry perspective, full repayment is not a penalty but statutory authorized compensation to protect public investment and ensure accountability in government-funded education. And next. In conclusion, Aida relying on Section 75 of the Contract Act 1950 is legally misplaced. Scholarship agreements involving the government are governed by the Contract Amendment Act 1976, which expressly prioritizes the protection of public funds over individual hardship. Upon breach of a scholarship bond, Section 5 of the Amendment Act mandates full repayment of the bonded sum, and the court are deprived of any discretion to reduce the amount on grounds of fairness. Accordingly, the Ministry of Health is legally entitled to demand full repayment, and the repayment clause do not constitute an unlawful penalty. As a legal advice, Aida is unlikely to succeed if she challenges the enforceability of the scholarship bond in court. Aida should not dispute liability, but instead examine the scholarship agreement to determine whether any administrative discretion, hardship relief, or repayment flexibility is available. In the absence of such provisions, she could persuade a negotiated administrative solution with the Ministry of Health, such as repayment by installment of deferred payment terms. This approach is far more realistic and commercially sensible than pursuing litigation with minimal legal merits. That's all for me. Now I will pass it to Chifa.
Thank you, Winnie. I will now address issue 5, which concerns the house purchase in Seremban between Aida and Laila. So the issue here is whether a binding contract was formed when Aida later agreed to buy the house at 500,000 when she had made a counter offer at 450,000. So under contract law, Section 7 sub A states that an acceptance must be absolute and unqualified. An acceptance must be an unconditional assent to the terms proposed in the offer, and the acceptance must not have any conditions attached to it. A counteroffer arises when the offeree responds to an offer by proposing different terms and it destroys the original offer and brings it into the end, meaning the original offer cannot later be accepted. Next. So the principle was established in Hyde and Wrench, where the defendant wrote to the plaintiff offering to sell his farm for £1,000, and a counteroffer was made for £950, whereby the defendant had replied that he was unable to sell at £950. Upon receipt of the letter, the plaintiff immediately wrote to the defendant accepting the defendant's earlier offer of £1,000. And the question was whether a contract had been concluded between the parties. The court had held that there was no binding contract. In this case, the plaintiff did not absolutely and unconditionally accept the defendant's offer price of £1,000, and by proposing a different figure, the plaintiff had rejected the defendant's offer and now makes a new counter-offer, whereby it destroys the original offer and he cannot now revive it by tendering a subsequent acceptance. Next. This must be distinguished from a mere inquiry, which simply asks for clarification on whether different terms may be considered without rejecting the original offer. In Stevenson, Jacques and Co. and McLean, the parties were negotiating for the sale of iron. The defendant had offered to sell iron at 40 shillings per ton net cash and stated that the offer will remain open until the following Monday. The plaintiffs then asked whether the defendant would accept delivery over 2 months, or if not, what is the longest delivery period will it be? The defendant did not reply and instead sold the iron to a third party, later informing the plaintiffs of this sale. And before receiving this notification, the plaintiff had sent another telegram accepting the original offer at 40 shillings per ton. So when the defendants refused to deliver the iron, the plaintiffs had sued for non-delivery. Next. So the issue here was whether the defendant's words amounted to a counteroffer or an inquiry. The court had held that the plaintiff's earlier telegram did not amount to a counteroffer, but was merely an inquiry seeking the clarification of delivery terms. Accordingly, the original offer remained open and was validly accepted by the plaintiffs, which had resulted in a binding contract. Next. So, from Ida's perspective, she may argue that her response offering 450,000 was part of ongoing negotiations and should be treated as a mere inquiry, similar to the situation in the Stevenson, Jacques and Co. case. And in that case, the court held that a request for clarification did not amount to a counteroffer and did not terminate the original offer. So Ida could contend that she did not expressly reject the 500,000 price and that her later message agreeing to purchase at 500,000 demonstrated her intention to accept Lila's original offer. So from a practical standpoint, Ida may believe that it was reasonable to assume that the offer remained open. However, from Lila's perspective, this argument cannot succeed. Unlike in Stevenson, Ida's response did not merely seek clarification but proposed a definite alternative price. Her proposal therefore constituted a counteroffer and not a mere inquiry. And by applying height and range, a counteroffer has the legal effect of terminating the original offer. And so by proposing new terms, Ida had legally rejected the original offer of 500,000, and once Lila rejected the counteroffer made, the negotiations will come to an end. And since Lila did not renew the original offer, Ida's later attempt to accept it was legally ineffective, and Lila was under no obligation to proceed with the sale. Next. So in conclusion, no binding contract was formed between Ida and Lila, and Ida's offer of 450,000 constitutes a counteroffer, which legally terminates Lila's original offer. Also, Ida's later attempt to accept the original price was legally ineffective since the original offer had already been terminated by the counteroffer and there was no longer an offer available for the acceptance. And in light of this, Lila is under no legal obligation to proceed with the sale of the property. She is free to reject Ida's subsequent acceptance or negotiate on new terms, as the original offer no longer exists in law. And legal advice that could be given to Ida is that she should always be aware that making a counteroffer terminates the original offer. So if she intends to accept Lila's original offer, she must confirm with Lila that it is still valid. To avoid confusion, any agreement should also be documented in writing, and Ida can also consult legal counsel for advice on contract negotiations and the implications of counteroffers in future deals. And overall, this case reinforces that principle that a counteroffer operates as a rejection of the original offer, emphasizing the need for clarity and precision in contractual negotiations. Thank you. That's all.
Thank you.
Thank you.